Welcome back. I hope you found that exercise useful. In this video, we'll discuss patents, trade secrets, and trademarks in greater depth. Patents cover a breadth of intellectual property ranging from processes and designs to biological. Let's look a little more closely at each type of patent. Process patents describe processes. These are the steps and methodologies to produce a particular result. This could include industrial processes like heat treatments or food preparation processes. Utility patents describe the function of a product. Imagine a machine that can accomplish a novel task. The function of that machine can be covered by a utility patent. Then we get into design patents. Design patents describe a particular design. This covers the physical appearance or aesthetics of a particular item. This type of patent covers everything from the design of a smartwatch to the architecture of a skyscraper. Finally, there are biological patents. These type of patents cover unique man-made biologies. Some good examples would be Roundup-ready crops or vaccinations. Selective breeding and genetic engineering have created novel biological products or enabled targeted therapies. These are costly endeavors, and with patents, companies have a means to protect these products. The more complicated the invention, the more complicated the patents can be. Many inventions require multiple patents, spanning the types of patents I've covered here. Patents are publicly searchable, as copyright of the patent is transferred to the public domain as a condition of granting a patent. Patents are their own protected class of intellectual property, so copyright is surrendered to access the protections offered by patents. Patents have certain limitations. Notably, unlike copyright, patents are not automatic. They must be filed with the U.S. Patent and Trademark Office. This can be a costly process and may require lawyers for reasons that will become clearer as we consider other limitations. Patents are also time limited. They expire after 20 years from the date of filing and are not renewable. They may expire earlier if maintenance fees go unpaid, but they cannot extend beyond that period. Some consider patents a way of getting intellectual property into the public domain as they expire so rapidly. This might be the case for certain patents. Some IP owners may want their products to be broadly adopted, like the Tesla patented North American charging standard. But in other cases, it's a legitimate means of protecting products from being copied and causing economic harm to the intellectual property owner. Patents must also be patentable. That sounds obvious, but what that means is that the utility design, process, or biological products must be novel. This is where lawyers may be necessary. They have to establish that a patent does not constitute prior art. They must also be non-obvious. For example, a tire manufacturer could patent a tread pattern, but they could not patent a round wheel. That would be an obvious and non-novel design. Patentable items are also useful. There needs to be some utility to the patented property. All of these limitations are why it's often necessary and wise to involve lawyers. They can help navigate those limitations. Finally, I want to note that as graduate students, you are likely required to transfer ownership of any patentable work produced as a product of your studies or research to the institution where you are studying. You are likely considered an employee of the institution, and as such, patentable work you create within the scope of your studies and research are the property of that institution. This is not the case for most undergraduate programs. So what about things you don't want to enter into the public domain? When you hear words like proprietary in a business context, it's likely that it is a trade secret. Trade secrets are also protected by the law so long as they are not generally known to the public. That makes sense, right? A trade secret must be kept a secret. Reasonable efforts also must be made to protect the secret. This may include requiring employees or contractors to sign a non-disclosure agreement. Finally, the secret must have economic value. It would be impossible to assess a loss if there is no economic harm done to the individuals, or entity owning a secret. You might be asking, why would anyone risk a secret being disclosed? Trade secrets are still protected under the law, and there is no expiration. So things like industrial processes that cannot be easily replicated or reverse engineered from publicly accessible products might be advantageous to be kept secret. Think about a searching algorithm like Google. They don't want their secret sauce to expire, so they keep the algorithm a secret. Finally, we get to trademarks. Trademarks can cover signs, designs, and expressions that differentiate products and brands. For example, McDonald's Golden Arches logo is a trademark, but so is the name of its signature burger, Big Mac, and so is its slogan, I'm loving it. Like patents, trademarks must be unique, but may or may not be registered. A registered trademark is protected for 10 years from filing, but that can be renewed indefinitely. The reason for registering is that it provides broader legal protection, but unregistered trademarks are still protected within the geographic area of operations as soon as they're put into use. I'm sure you've seen the marks on the bottom of this slide before. These denote registered trademarks and trademarks, respectively. When counterfeit items are sold, they may be violating patents, but almost always they're violating a trademark. So far, we've covered the basics of intellectual property and gone into a little more depth with patents, trade secrets, and trademarks. Next, I've prepared a quiz to revisit some of the material we have covered. Then we're on to copyright.